for inviting me to speak to you. It's a great honour. I have addressed this branch before, but a number of years ago, as John Burgess will recall. Employment rights in the COVID workplace. Let me deal with this at two different levels. One is to speak generally about what a COVID-19 crisis has revealed about what we call labour law, that's to say the law of the workplace. And having said a few things about that, let's focus on more practical bits of law that it may be that you could actually use in the workplace. So talking about it more generally, what COVID-19 has revealed, I think, to many people, if not most of the people in this country, is the absolute failure of labour law to protect workers. Now, many of us who are labour lawyers have been saying this for a number of years. We've watched the way that the rights and freedoms and collective power of workers has been cut since 1979, 40 years ago, when the Conservatives were first elected and Thatcher came to power. And we've seen those rights diminished and diminished and diminished. Process was halted when Labour came to power in 1997 until it was the Tories were elected again in 2010. But since 2010, the attack on workers has been absolutely years of austerity are well understood, particularly in this audience. But I just want to highlight I think particularly revealing about the failure of labour law generally. First of all, income. The laws in this country have not protected the income of workers. It remains a fact, as the UN rapporteur for poverty pointed out 2 years ago, that 14 million people in this country live in poverty, below the poverty line. 9 million of them live in families where there is a wage earner. And that indicates, I think, absolutely conclusively that wages are so low in this country that they cause poverty. And we've seen this, of course, replicated in the course of the COVID-19 crisis, because we now know, as Helen mentioned in her opening, that Black, Asian and ethnic minority workers have had a higher incidence of COVID-19 and a higher death rate than those who are not in those categories. But the statistics also reveal, and the statistics published by the Public Health England this week, which are in fact only repeating what the Office of National Statistics revealed last week, we now know that those most likely to catch COVID-19 and those most likely to die of it in the workforce are those who are the lowest paid. Now, this is no surprise, of course, because the better paid workers often have the privilege of working from home on their computers. But those who have to go out and actually use their hands, with a single exception of doctors, are badly paid. And this crisis has revealed that. But even the legal protections that we have for against low wages are flouted. Last year, let me tell you, if I find the figures, last year in 2019, there were no less than 246,000 cases which the Inland Revenue reckoned of people who were paid below the national minimum wage. And in 2019, they reckoned 25% of those who were entitled to be paid the national minimum wage were not paid the national minimum wage. And that had risen from 20% in 2018. So the protections against low pay are not, in fact, working in this country. So that's income. What about security of employment? Well, we now know that there is virtually no security of employment for anybody in this country, apart from the very highest earners. The Office for Budget Responsibility estimates that there's going to be 3.5 million people unemployed as a consequence of COVID-19. The Bank of England a couple of weeks ago reckoned that it would be 3 million. Well, whether it's 3 million or 3.5 million, that's an awful lot of people who are going to lose their jobs and their livelihoods. And labour law doesn't protect them. There's no way of stopping it. Of course, there are requirements for pay redundancy pay, and if they're unfairly dismissed, they've got maybe a claim for unfair dismissal. But a third of the workforce don't have any protection against unfair dismissal, even if they're employees. The reason? Because they're not employed for the necessary 2 years first. And then we've got a group of workers who've got no employment security whatsoever of any kind. The gig workers, the casual workers who are employed for the day or for the week or possibly for the month, and who can be told that they're no longer required because the work isn't there, without any redress whatsoever. And the TUC reckons there's about 7 million people in those categories with insecure employment. And then thirdly, and penultimately, there is the lack of protection against health and safety at work. I mean, I don't need to tell anybody in this audience about the failure to provide personal protective equipment, even to those who are most exposed to the risk of contracting COVID-19, our health workers and our care workers. And for the rest of the working population, PPE is against COVID-19 is virtually non-existent. Yet, as I'm going to explain in a moment, we have laws that require personal protective equipment to be supplied to workers who are at risk. So our labour law has failed on that front as well. And the fourth and final area that I wanted to draw to your attention is one that, of course, you'll be very familiar with as trade unionists. It's the failure to ensure industrial democracy, the failure to protect the voice of working people, the failure to ensure that working people have a say in the terms and conditions of their working lives. Now, no doubt, as public sector workers, you have more say through local collective bargaining and national collective bargaining than many other workers. But let me just remind you that in 1979, when Thatcher came to power, 82% of British workers was covered by a collective agreement. That percentage now is less than 26%. I reckon it's around 23%. And in the private sector, it's only just into double digits. That means that for all those workers, 8 out of every 10 nearly, they have no union negotiating for them. They have no say at work. All jobs are on a take it or leave it basis, and even changes to their employment conditions are, well, if you don't like it, push off and get another job. So we've got a major failing in industrial democracy, which labour law has not protected. So that's, Helen, what I wanted to say by way of introduction, a sort of overview of what COVID-19 has revealed about the state of our labour laws. Then I wanted to speak a little bit more about some of the laws that it may be that as trade unionists you can actually utilise at the workplace. And I want to begin with the health and safety law, which we touched on a moment ago. 2 weeks ago, the government published 8 guides. These were guidance for returning to work, and each one dealt with a different sector of the economy. Last week it published a 9th one dealing with retail workers. And what's remarkable about those documents is that you can read them from end to end, and you wouldn't realize that there is specialist legislation making it a criminal offense for employers not to maintain and provide a safe workplace. And there are many reasons why the government doesn't want to draw that either to the attention of employers or workers, and I'm sure you can guess at what they might be. But what I thought might be useful, Helen, is if I just remind the audience of what some of those legal requirements are, and then anybody who wants to can look online and find out what the actual words are. Well, there are 2 sources of health and safety law. One is the common law, the law of negligence, and that says effectively that every employer has to provide and maintain a safe place of work, a safe system of work, a safe staff and safe equipment. And that's a common law obligation, and that's the law, of course, under which workers who are injured or suffer diseases contracted at work or even die at work are able to bring claims for damages. In addition to that, there are statutory provisions, beginning, of course, with the Health and Safety at Work Act 1974, which sets out general duties. But under that act, there is also a set of regulations. And I just want to mention some of those regulations to you. The first regulation I want to mention to you is the Workplace Health, Safety and Welfare Regulations of 1992. Their relevance in the coronavirus situation are that they provide in Regulation 9 that every workplace and the furniture, furnishings and fittings therein shall be kept sufficiently clean. And in Regulation 10, every room where persons work shall have a sufficient floor area, blah, 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 for the purposes of health, safety and work and welfare. And Regulation 11, every workstation shall be so arranged that it's suitable both for any person at work in the workplace who's likely to work at that workstation and for any work of the undertaking which is likely to be done there. And there are other provisions as well. Suitable and sufficient washing facilities have to be provided with hot and cold water, towels, soap, and suitable drying and so forth. So that's one regulation of significance. Then there's the Control of Substances Hazardous to Health regulations, which the lawyers call the COSH regulations of 2002. And that covers substances hazardous to health, which clearly covers the virus COVID-19. And that requires, in Regulation 7, that every employer shall ensure that the exposure of his employees to substances hazardous to health is either prevented or, where this is not reasonably practicable, adequately controlled. Then you've got the Personal Protective Equipment at Work regulations of 1992. That says in Regulation 4 that every employer shall ensure that suitable personal protective equipment is provided to his employees who may be exposed to a risk to their health or safety while at work, except where and to the extent that such risk has been adequately controlled by other means which are equally or more effective. Now, that is an absolutely vital consideration that every employer and every worker should know, because what it means is that if there's no other way of eliminating the risk of infection of COVID-19, whether it's by social distancing or hand washing or putting up physical barriers between workers or whatever, if there's no other way of doing it, then personal protective equipment must be provided. And that PPE has to be suitable, and it has to be appropriate for the risk or risks involved, the conditions at the place where exposure to the risk may occur, and the period for which it's worn. And furthermore, I'm reading the regulation, it must be capable of fitting the wearer correctly. And that's very important, because these gowns that have been provided to doctors are often too short, or the arms are too short, or it's got no covering at the back to prevent the infection landing on absorbent clothing and so forth. And the last point about that is that the PPE has to be, and I quote, effective to prevent or adequately control the risk or risks involved. So this is cast iron stuff. I mean, everybody who's comes into contact with other workers at work or with members of the public ought to have this engraved on their forehead. Finally, I mentioned the Management of Health and Safety at Work Regulations 1999, which are the regulations that require every employer to make a suitable and sufficient risk assessment, which a lot of employers are not doing. So the point about these things is that if one is in negotiation with an employer and saying, look, hang on a minute, this isn't safe, we need PPE here, it's worth pointing out that under Section 34 of the Health and Safety at Work Act 1974, it is a criminal offence to breach the regulations that I've mentioned. This is a criminal offence, and that criminal offence is not merely committed by the employer, but if an individual is responsible for that breach, then the individual can be criminally liable as well. And that, of course, will apply to managers. Now, of course, we're all realists in this virtual room. We know perfectly well that nobody's going to get prosecuted over this, or at least not for a very long time. And we also know that the health and safety executive is so underfunded that the average workplace can expect an inspection every 260 years, and that offices, which is what most of you guys work in, I assume, are under the inspection regime, not of the HSE, but of the local authority environmental health officers, of which there are 543 full-time equivalents for 1,700,000 separate premises in this country. So the chances of there being an inspection followed by an improvement notice, a prohibition notice, or a prosecution are negligible. But of course, your managers don't necessarily know that. And you have the opportunity to use these arguments in arguing for a safer place to work if you have to go to work. Now, the final provision, Helen, if I've got 2 minutes longer to mention, is Section 44 of the Employment Rights Act 1996, or Section 100 of the Employment Rights Act 1996. These are the sections which say that a worker cannot be penalised for refusing to work if she has if she reasonably believes that there is a serious and imminent threat to her health. Now, anybody entering a room where they think there is a risk of infection, I would have thought it goes without saying that that is a serious and imminent risk, and that risk must either be eliminated by one of the various methods of doing so, or the worker must be fully protected by PPE. And if that's not the case, then the worker is entitled to say, no, I'm not doing that. And they should be protected by Section 44, which protects against detriments, and Section 100, which protects against dismissal. Now, of course, wearing our hats as realists, we all recognize that employment tribunals at the moment are not conducting full substantive hearings. They're only dealing with procedural matters. And if you were to lodge a claim now, the likelihood is that it wouldn't be heard in front of an employment tribunal until the end of 2021 at the earliest. But that doesn't mean that you can't use the argument about these sections and draw those sections to the attention of your employer if faced with a risk. And if that argument is mounted by lots of workers rather than a single worker, it's a more formidable proposition for the employer to confront. Helen, I've probably said enough for the moment. There may be other questions about breach of contract or people having their wages reduced without their consent and that sort of thing. If anybody has such a question, I'll try and deal with it to the best of my ability.
Okay, thank you very much.